Mm. Hello, those are the things that you need to address in your terms of use to make sure that they are enforceable and protect you from liability to the maximum extent allowed by law. So let's go through them one by one. Start your terms and condition by naming the company owner and stating clearly that the terms are legally binding. Now, the reason to name the company and not you personally is to make sure that in case there is liability event, then it's the company that's going to be liable and not you personally with all of your assets. In case the company that owns the platform doesn't really own anything, then there's nothing that users can sue the company for. State that the terms apply to all visitors of the website and or application. If you have both website and an app, then you can say that the terms of use apply to both. And this way you don't have to modify multiple documents whenever you're updating. You can just update one single set of documents. Legal acceptance of the terms. In that section, you communicate that by using your platform, website, or an app, users agree to be bound by the terms and conditions and also your privacy policy, whatever acceptable use policy you might have. This is the right place to say that the users, by using your website or app, will be legally bound by those documents. And the more prominent, the more in their face it is, the higher likelihood of enforcement. Now, a good place to place these acceptance boxes is when people check something out, when they register for an account, you can list the main terms of your website, the main disclaimers, and whatever else is important to you. So let me give you an example of all of this coming together. The introduction and the acceptance. Terms of use govern your visits to the site and or mobile application. Collectively, they're referred to herein as the platform. Then you put in the company name who owns and operates the platform. And now you have a single set of terms applying to both your website and an app. So as far as acceptance, it says terms have force of legally binding agreement. Link your privacy policy, whatever other policies you have that are important for you to enforce, and say that if people visit your website, that automatically constitutes their legal acceptance, their legal agreement with those documents. All right, moving on to the third important item that would be account registration is security. This is more technical than legal in nature. This is, so I'm not going to spend too much time on it. You know how people sign up for website, what is it that they have to do, what information they have to provide, what kinds of memberships you have, service levels, and so forth. This is a good place to describe that. Moving on to the privacy policy. You don't include it with the terms of use, but include a link and say that in the terms of use that the information collected is processed in accordance with your privacy policy, and then include the link. Now make sure also to address any third-party services that are also collecting user data, and it'll help shield you from liability if you say that, well, third-party services are not affiliated with my service and they have their own privacy policies, so read those and make sure you comply with them. Payment terms, refunds, exchanges, clarify what payment methods are available to people. Fees, shipping policy, refund policy. So moving on to IP. So that's important. Basically, here you will say that what's yours remains yours, and what's users remains theirs. The content of your platform, logos, images, your trademarks, that would be your property, and user submitted content remaining their property. So here is an example of that clause when it comes to your IP. And here is an example for the user submissions, the user IP. It basically says that you don't claim ownership over it. So moving on to user-generated content. This is also part of the IP ownership issue. Needs to be addressed. Who owns it? What are the rules for submission? And closely related would be copyright infringement. DMCA notice. Here's an example of a basic one. Now we're going to move on to limitation of liability. That's important. That's probably the most important section that there is, because regardless of what type of platform it is, you want to be protected to the maximum extent. And you do that by including a disclaimer of warranty and limitation of liability clause that basically says the services provided. Here's an example. Platform is a neutral venue. Your role is limited to providing technology to connect users, and you're not held liable for users' data, transactions, interactions, information, and the consequences of them disclosing their personal information to each other. Now, why is this important? Now, especially for if it's a social media platform that you have, dating network, jobs site, anything where people exchange information a lot, and you don't want to be liable for what is it they're posting, how they're using each other's personal information, what is it, basically anything that they're doing on your platform, you don't want to be liable. And if you have that neutral venue clause that limits your liability, the reason it's important is the law gives you protection. Section 230 of the Communication Decency Act basically shields you from liability as a platform owner for how people use your platform, as long as you remain neutral, as long as you don't participate in the creation of the content, then you will not be liable. So to reinforce that fact that you are a neutral, in fact, platform, this is a good clause to use. If you have any sort of financial trading advice, you need to have a non-financial advice disclaimer, because rest assured, people will follow your advice, lose money, not because it's bad advice, but because, you know, it's internet. And they will sue you. So to prevent that from happening, no financial advice disclaimer. If your platform has anything to do with health, wellness, medical information, have a no medical advice disclaimer. Mm-hmm. All right, so the neutral venue, if you have a financial platform, then non-financial advice disclaimer. Medical platform, no medical advice disclaimer. And we're moving on to governing law and jurisdiction. Why is this important? Well, you will have users all over the country and the world maybe. And in case there is a dispute, consumer law of their jurisdiction, their state or country may give them right to sue you where they are. Whereas it would be more convenient for you to have the jurisdiction of for the disputes close to where you are, and to make sure you don't have to travel way out there or hire a lawyer there. You have governing law and jurisdiction clearly specifying the law of which jurisdiction governs the disputes and where they should be resolved. Now, remote arbitration is something to consider here. It can work in substitute of courts. If you have arbitration, that means the disputes will be resolved. If it's a document-only arbitration, they will be resolved by email, Skype, Zoom, and so forth, but without anybody having to actually go for in-person hearings. So that's definitely a good option. And in conclusion, you need to make sure that you have the right to modify the terms at any time, and encourage people to periodically review the terms to stay informed. So regardless of what type of website you have, by addressing those 10 things, you will be very well protected. Other things include usual boilerplate as far as severability, prevailing language, waiver. I'm not going to spend much time on it. Standard clauses, you can look them up. And you will be in a pretty good shape. And let me know if you still have any questions.